when things are good between people, the thought of all of the documentation, etc., really doesn't cross their mind. But then things go sour, and all of a sudden it's like, I wish I had the documents. So, and I've said this before, the reality of contracts is they're only necessary when people don't live by them. Hello, and welcome to the next episode of Beneath the Law. I'm Gavin Tighe. Stephen Thiele, how are you today?
I'm good, Gavin. How are you doing?
I am pretty good. We're heading into a long weekend here in lovely southern Ontario and winding down what was a excruciatingly hot but beautiful summer.
Gavin, we're lawyers. We don't have long weekends. They don't exist. Haven't you figured that out yet?
Long days and long nights, but no long weekends. How's that? So speaking of hot situations, the housing market and the affordability crisis, as it's been called, is a big deal. I mean, for young people trying to get their first home, it's almost insurmountable, the cost of a house these days, given what people are making and the fact that the amount of the down payments and the stress tests and all the rest of it. And it really is a serious challenge for this generation to try to own a home.
100%. And, we know from a political standpoint that government is not building homes the way that they used to. Certainly after World War II, a lot of homes were built. Starter homes, I guess they would be called, which were affordable for people coming back from the war and young families. But certainly in the big cities, and even outside the big cities, Gavin, I'm shocked at the prices, 2 hours north outside of Toronto for housing.
Oh, yeah. Look, I mean, you can't look at a garden shed in Toronto for under $1 million. And in order to even think about, buying that, you have to have a substantial amount of money to put down as a down payment. I think to qualify, if on $1 million house, you'd have to have at least $100,000 in cash to put down.
Oh, probably more than
Probably
that.
more
You
than
probably need something like $250, isn't it? 25%.
And for someone just starting out, $100,000 or $200,000 in cash is a lot. After tax money is a lot of cash.
Yeah, and young people aren't making that kind of dough.
And certainly not only are they not making it, even if they are, the cost of everything else, rent and food and just life, is so high that it's impossible for many younger people to put that type of money aside. And by the time they do, they're not younger anymore. They're old fogies like you and I.
Speak for yourself.
A lot of parents. Oh, well, you're young at heart. A lot of parents will seek to help their kids out. And kids who are fortunate enough to have parents who can help them out with some of the money towards a down payment. And that is an interesting dynamic because it's always a tricky situation with people who are handing over, sizable amounts of money, like in hundreds of thousands of dollars, $500,000. And, the notion that, okay, here you go, here's $500,000, no strings attached. That's a pretty big deal. I mean, that's a pretty nice gift, if you will. So we're to talk about this very, very common practice that parents helping out their kids. And the other thing too, is that oftentimes the big issue for a lot of parents is, well, I want to help out my child, but they're married and I'm going to give them some money to put down on a new home, of course, which they will live in with their spouse. And at least in Ontario, that raises a whole series of issues because you may say, I'm very happy to see my child get a few $100,000. That's great. But, I was going to give it to them when I die anyways. Might as well give it to them now. But I really don't want that if things go on the rocks in their marriage. I really don't want this, person who is not my child and who may be my ex-in-law, getting half of my money. And theoretically, the matrimonial home, regardless of who owns it, if it was bought with, with one, with an occupied as such, they may have a claim to it. So a lot of people are very, very hesitant to kind of let go of the money, no strings attached.
Well, and look, I mean, this is kind of a common dispute that we've seen in the law, every year. I mean, these cases come up where, as you say, parents help out their children, or there's other what are called inter vivos transfers to other relatives, or spouses, or girlfriends, boyfriends, that kind of thing, of significant amount of money. One of the people takes the property in their name, and the party that's given the money does not have their name on title. And so disputes arise, in cases of certainly a matrimonial breakdown where there's another person involved, or just certain, just in terms of other breakdowns. Families don't necessarily get along all the time, and dynamics shift. And all of a sudden, the parent or the person who's given the money wants their money back, or they want to claim a beneficial interest in that property.
Yeah, same difference. I mean, the issue becomes that what was once a gift now, is not seen as such. And let me throw
Or was
another.
it a gift in the first place?
Well, it may be.
Right.
One of the problems I think that you get into now, and this is really probably the real dynamic, is the third wheel in this equation is the bank. And banks are saying, okay, that's great. You need to put down X dollars to buy this house, or we won't give you a mortgage. They want you to have equity in the property. They are only going to lend a certain percentage of the value of that home, and they want the rest of that value to be covered by you with your money. In other words, that's really where the risk in home ownership is that first layer, or the deposit money, because that the bank is looking at it like, well, even if the value drops, we'll still get paid. There's still enough equity in that house for us to get our loan out, but we want your money in there first. But the key point is it's got to be your money. What they don't want you to do is go out and borrow money from somebody else, so that in fact you have no equity in the property. You're just got a bunch of debt, and a house in your name, and then they're left try to recover on it. So banks will require very, very often, I think almost always, that if a parent is helping out a child, for example, on the purchase of a home, and that's where the money's coming from, then the parent is required by the bank to sign a gift letter. In other words, to say, you parent aren't a creditor anymore. You parent don't have an interest in this. You are giving, no strings attached, this money to your child, such that the money that is going into the transaction is the child's money. The title to those funds has transferred, no strings attached. And I think you see that very, very often in almost every mortgage situation where the funds are coming from a parent.
Well, I think that's becoming more common. And just for the listener, what we're talking about is the law of resulting trust, and gift, which kind of arose in a very recent decision. And like I said, there's lots of decisions that come out on this quite regularly. About a father. The case is called, I'm going to just call it Clemens, because the first, the name of the other, last name of the other person is a little bit, will be a word salad kind of name, and I'm certain I'm going to mispronounce it. So I'll call it Clemens, with a K, by the way, not a C.
Mr. K.
So it doesn't involve Pinball Clemens. It's a K Clemens, or Roger Clemens. So we had a father who gave his two children over $500,000 to buy a house.
Well, gave is the operative word. He
provided. That's a better
money
word.
Moved from dad to kid. The vehicle by which it moved was the issue. Was it a loan? Was it a gift? And it's interesting to me that I think it was his biological son and his daughter-in-law. And what was interesting to me was the advance of the funds. to be generic, occurred because the son and the daughter-in-law lined themselves up with the father in his divorce.
Right,
So
in his divorce. That's
they
right.
took his side in the divorce, and he rewarded them, or didn't. I don't know if he rewarded them, but he moved in with them. And then they needed to buy a bigger house, and he, as you say, advanced over $500,000 that they could put down on the new purchase. Suffice it to say that the alliance that had existed in the divorce seems to have broken down at some point.
It sounds like alliances between different countries.
Yeah, it
They
was.
go
Yeah,
along pretty good, and
yeah,
then something else happens. Somebody gets elected, and away you go.
yeah. It was. Well, anyway, so the whole the way it rolled. I mean, we don't certainly don't know from the case all of the salacious details of the breakdown of this family relationship, but ultimately the the father and the son had a falling out. The father said, "Give me my money back." The son said, "No, no, no. It was a gift." Um, Fortunately for the son, the bank had required, I think required. I don't think this was an option. I think the bank said, "Look, Dad, if you're giving the money, you got to sign a letter that says you're giving the money. It's an irrevocable gift, and it's son's money." And Dad had signed that, presumably as part of the package to get the mortgage in the first place.
Yeah, and I think that's what's really curious about the case. I mean, uh, the father wanted to claim the resulting trust, a proprietary interest in the property. And there seemed to be some evidence that when the money was first given, he was supposed to be on title to the property, which would have definitely protected his proprietary interest in the property.
Right.
Um, uh, but his name was not put on title. And, then he signed this gift letter, which, as you say, it was basically unconditional. The money was non-repayable, and he acknowledged that it was a gift. The children signed an acknowledgement as well that they received the money as a gift, and, away they went living together. I think it's almost 15 years or so. And then the father comes back at that period of time and says, "Hey, by the way, I have an interest in this property."
Or you
And
owe me 500 grand.
yeah, or you owe me, well, 500 grand as a loan. I mean, if once you say that there's a loan, you're not getting a resulting trust in that. I mean, that's a different transaction.
No, or resulting trust in resulting trust is, for the non-lawyers listeners, um, the law creates this fictional trust, if you can call it that, as a remedy to address certain situations. And if I recall correctly, the notion of resulting trust came out of family law. And to begin with, I think it was the Pectus and Becker case was the one, or
Right.
kind of remember. But what that was is that the loss, there was an issue that, the spouse had worked and put money into this property and this business, et cetera, as I recall it, and then had no actual official interest. And so the court said, well, yeah, but they put benefit into the property and or the asset. Therefore, we're going to say they have a beneficial interest, a trust that results from their input of value.
Right. And that's, I mean, there are a couple of concepts, right? There's the resulting trust, and then there's the constructive trust. The resulting trust is much more where there is that transfer of some kind of funds that somebody else uses and puts essentially property in their name, in most cases. And the law presumes that when there is a gratuitous transfer or a transfer without consideration, that the person who's providing the funds actually takes the ownership in the asset that is purchased with those funds, right? And so now,
Right. I'm mixing my metaphors between
right,
constructive and resulting. I apologize. But both are remedies that the court makes up, frankly. They are after the fact. Nobody, there's no deed of resulting trust. What it is a remedy that the court imposes based upon the injection of value into an asset, either through blood, sweat, and tears or cash.
correct,
And
right,
as I think it's also important for the listeners to understand that courts generally don't like gifts. Gifts is a presumption against gift, and the court presumes it can be rebutted in the sense that you can prove that it was a gift. But you can imagine that for particularly in estate issues, where someone got a large sum of money from a deceased person before they died, and then there's a death, and then the estate comes along and says, "Oh well, you got to pay this money back," and they say, "Well, no, 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 it was a gift." I mean, frankly, everyone's going to say that. So what the court says is, well, you could say that the dead person's not here to say different, but you got to prove it. The onus is on you to prove that it was a gift. We will presume that it was not a gift. We will presume that it was a bargain, a loan, whatever, unless you can show something to the contrary. So, like if you had, I don't know, a letter that said, "Oh, here's my check as a gift to you for $1 million, and I hope you enjoy and live a long, happy life." Um, that would be proof. But there has to be some corroboration, I would think, or somebody or a lawyer that was involved, or even anybody that was involved. Someone who's a witness. They can say, "Oh yeah, 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 no, that was a gift. They told me that they had given them the money to this person, or I was there when they did it," that type of thing. But otherwise, unless the person who claims gift can prove on a balance of probabilities that it was a gift, it's not a gift.
Right. And so you've added the twist in the case where the let's call them the donor or the transferor, the person who provides the money, has died. The Evidence Act actually contains a provision in Ontario that requires the recipient of those funds, where the estate brings an action, to corroborate their evidence. And they can't just rely on, a he says, she says kind of paradigm and say, well, it was a gift. There has to be some other evidence, clear evidence that supports or corroborates the fact that it was a gift. So that's their onus.
I'll give you a factual example. It's funny because I remember it very, very well, because it was actually the first trial I ever did as a lawyer related to a claim of gift. And it was, as would probably not be an unusual situation with the person who had advanced the funds was the ex husband of the person who had received the funds. There was all sorts of argument about whether it was a loan or a gift. He said, no, 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 it was a loan. They said it was a gift. We won the case on the basis that there is a presumption, and the evidentiary burden fell on the person claiming gift. And actually, it's funny because I know that now the test now is a balance of probabilities, but back then, that was a long time ago, 32 years ago, I think was my first trial. It was beyond a reasonable doubt.
Oh, wow.
You had to prove that it was a gift. So the law has relaxed a bit in terms of the burden of proof. That now it's only on the usual civil standard of balanced probabilities, but it used to be almost impossible to prove gift if it was just a he said, she said contest without some sort of contemporaneous evidence. And I think now maybe it's a little easier. The court can believe one party over the other. But as you point out, if the person is deceased, you got to have something more than that, because they're not there to deny it.
Yeah, and look, I mean, we're seeing this as I said, more and more often. We've got a population where inverted pyramid is what it's called, where we have a lot more older people than we have younger people in society. And as you said, the older folks, the old fogies, are the ones who have most of the wealth. The younger people don't have the wealth. And older people need a lot of care, as both you and I, have experienced with our own parents, respective parents. And it's pretty easy, particularly for elderly people who are isolated, to fall victim to people, whether they're caregivers or friends or others, to have funds transferred to them without consideration, And then for those people to say, oh, well, that money was gifted to me when, it really wasn't, or the elderly person may have been under some form of undue influence.
Right.
We just don't know, right? Which is why the law requires that corroborative evidence when somebody has passed away.
Yeah, I think that's a sensible precaution to prove that. As I said, everyone's going to say that. Anyone who received the funds, nobody wants to pay the money back. So if it was a gift, I mean, but the reality is, I mean, I think you have to look at that contextually. I mean, giving somebody $100 in their birthday card is one thing. I mean, start writing
Right.
checks for millions of dollars. Maybe not. So to me, that for significant amounts of money, particularly, and or valuable property, I would think that corroboration is important, and that could be a card. I mean, I'm kind of being facetious about that, but if you had a happy birthday card, here's I hope you have a great day, and there's a check for $1,000,000 in it. Okay, that might be
And
corroborating.
but it really gets to a what in my view, Gavin, is the most important point. I mean, you work in litigation as a trial lawyer, as a litigation lawyer. I work in litigation, supporting you in terms of back office, providing you with cases and that kind of thing, and helping develop the legal arguments. But at the end of the day, people should put themselves in a position to avoid litigation, and the best way to do that is to document. So if I'm the giver of the money,
Right.
I need to document that. Like, what is it? Is it a loan? Like, am I taking a proprietary interest? If it's a proprietary interest, put me on title to the property then. Or, at least document that. If it's a loan, document the loan with a promissory note or some other kind of thing. Take notes. Again, make them contemporaneous. That would be helpful, but it's not the best. But document. And on the other side, it's the same thing. If I'm getting the
Well,
gift,
this is the problem.
write something that at least acknowledges the gift. But people don't do that.
The problem is always this: by the time this is in front of a judge, the milk is soured, right?
Right.
So with the money changed hands, and in our case, for example, when Dad handed over the 500 grand, um, it was because they were in a good relationship. Things were good between them. Whether it was whatever the reason is. I mean, they didn't document it for all sorts of. If it was a loan, an undocumented loan, there must have been some level of trust. There was documents that suggested it was a gift, and I've
Right. The
talked about
bank.
why that
Right.
document came to pass. I'm kind of suspicious of it, to be blunt, because I think people know they have to do it in order to get the mortgage, so they do it. So whether it's actually is it really a gift? The short answer is, yeah, it really was a gift, because the letter was the end of the case as far as the father was concerned. But what people, what's hard for people, and I think I completely understand this. When things are good between people, the thought of, all of the documentation, etc., really doesn't cross their mind, because they're thinking, well, I'm never going to need that. I mean, this is my son. This is my, nothing's ever going to happen. But then things go sour, and all of a sudden it's like, I wish I had the documents. The reality of contracts, and I've said this before, the reality of contracts and most legal documents is they're only necessary when people don't live by them. I mean, if people do what they're supposed to do in a contractual relationship, nobody ever looks at the contract, because nobody's ever got a reason to complain about it. The only time the contract gets pulled out of the drawer is when somebody breaks it. So really, that's, contracts or any other legal document really are about when things kind of go sour. And that's, unfortunately, when things aren't sour, people don't like to think about it getting sour, but it does. And it did in this case. And the father who signed the bank letter that said, this is a gift, was stuck with it, even though I think his evidence probably was, oh, well, yeah, but that was just a formality I had to sign to get the mortgage, and really wasn't what it was supposed to be. The court didn't buy it.
Yeah, and it sounds like, too, Gavin, from a legal perspective, he seemed to want to shift the goalposts as the case went along a little bit, which also probably didn't help him very much. But
Yeah,
look,
no, he was incredible. Initially he said he was supposed to have a title interest, then he said it was a loan. He was all over the
right.
place.
So he,
ultimately it was anything but a gift as far as he was concerned. And I think what the court has to do, it's put themselves in the moment when the transfer of the funds occurs. What was in the intention of the parties at that time, not sort of, after the fact when, oh, I got mad at my son. Now I'm going to say that money is, it's a loan. People have changes of heart. The question is, where was their heart at the moment that the money was given over? And the court says it in the letter.
And sometimes that's very difficult. And that's difficult if there is no documentation.
It's well, as we pointed out, it's impossible, because if there's no documentation, oftentimes you won't defeat the presumption. You won't get over the hurdle of the burden of proof, because the presumption is that there was not a gift. The presumption is that it was a bargain of some description. So if you're the person receiving the funds, it's in your interest to get the birthday card. It's in your interest to get something in writing that said a deed of gift is a thing,
Right.
In the sense that it simply says that I am handing this money over to you. It is your property as a gift, and that is not in the interest of the donor of the gift. It is in the interest of the donee,
and it is their burden.
And so you not only have to look a gift horse in the mouth, you got to give them a piece of paper and a pen at the same time. Anyways, the bottom line was that Dad got nothing. Dad lost his $500,000. I expect that the relationship, I'm sad to say, and I don't know these people, but I'm always sad to see when a family is in this situation. I expect that having gone through a trial on this, that repairing that relationship will be exceedingly difficult. Stranger things have happened.
No, but you know what? Look, I mean, families are what they are. Everybody's got their own familial stories to tell. As you alluded to, I think in the family situation, it's very difficult sometimes to document things because, family members are, you got to trust one another, right? Your blood relations.
Right.
So.
And it's a hard thing to say to your parent, hey, thanks for the money.
Give me an agreement.
Can you sign this paper? Because it's almost saying to them, oh, like, I think you're going to change your tune for me at some point in time. So I think that's it is a difficult thing to do, but it matters, particularly in the situation, and you see this a lot, I think, in familial situations where a parent, for example, gives one of the children money because they needed money at some point in time, and it was a gift.
Yeah.
But then, when the parent passes away, the other siblings come along and say, hey, wait a minute. Why did you get that money? You got to pay that back to the estate so that I get my share of it too. So all of these things are important in regards to documenting properly a gift. But in any event, Stephen, that's always an interesting conversation, and this one I think pretty practical. So for people who are in the situation of helping out their kids, those gift letters that the bank makes you sign, they matter. So if you're really going to give a gift, give it like you mean it.
And that's because no one is above the law,
but everyone is beneath it.
100%.
Thanks very much, everybody. Please rate us, give us your reviews, comments, kudos, insults, name calling. We don't care. Any reaction is better than none.
No, don't insult us.
and please stay tuned. Tell your friends about if you enjoyed this episode, if it gives you some insight into legal matters in a real life application. Please tell your friends about it. We're always looking for new listeners, new subscribers. And Stephen, thanks so much. Talk soon. Cheers.